And if you have any particular questions about your situation, I will provide at the end of my presentation my contact information, and you can contact me directly, and we can discuss any particular issues you may have. So I will start by speaking on sponsoring a spouse to become a permanent resident of Canada. Both sponsors and applicants who are being sponsored have to meet specific requirements. And here I listed the requirements to become a sponsor. So the sponsor is someone who is at least 18 years old, is a Canadian citizen, or a person registered in Canada under the Canadian Indian Act, or permanent resident of Canada. This individual has to be living in Canada, or if they're living outside of Canada, they have to intend to reside in Canada after the sponsorship process is over. You can't sponsor someone if you're a permanent resident residing outside of Canada. With respect to financial eligibility, there is no low income cutoff for sponsoring a spouse. Therefore, only if you are not getting social assistance from the government, you then become eligible to sponsor. So anyone who is not receiving social assistance other than disability assistance is eligible to sponsor a spouse. And when you're agreeing to become a sponsor, you must sign an undertaking of financial support, stating that 3 years, for the period of 3 years after your spouse becomes a permanent resident, you're responsible for them financially. And again, that concerns specific financial support for basic needs for your spouse. And in cases where the relationship breaks down and there is a divorce, you would still be having to provide basic needs, financial undertaking for your spouse or former spouse if there is a relationship breakdown. So as I mentioned, the length of undertaking is for 3 years in this case. With this respect, being a sponsor, it's not only this type of requirements, but there are other particular situations that might prevent someone from being a sponsor. If the sponsor has criminal charges that include violent crimes, crimes against former partners or spouses, they might be banned from sponsoring for a period of 5 years. There are also eligibility criteria for the applicant to become permanent residents in that situation. And the starting point is that for spousal sponsorship, you have to be legally married. So simply the ceremony, that is a religious ceremony, would not suffice for this type of applications. The key document in this application is a marriage certificate. And it doesn't matter where you get married, in Canada or outside Canada, as long as it's a valid marriage certificate, that's what your sponsorship application will be based on. There are voluminous applications, application materials in each case. All depends on particular circumstances of the relationship. Generally, I advise my clients to prepare a relationship statement, gather letters from relatives and friends, describing the relationship in support of the applicant and the sponsor. Other documents, the proving relationship, photos of proof of trips together, financial support to each other, and that goes for financial support from sponsor to a spouse, but in some cases the roles are reversed, and the sponsored spouse provides also financial support to the sponsor. So it all depends on a particular case, what type of supporting application documentation you will be accompanying the immigration forms with. And generally, currently, the processing times, they vary by the type of sponsorship, and you may know that you can file the sponsorship within Canada for in Canada processing if your sponsored spouse is residing with you in Canada. But also with respect to the overseas file sponsorships, the sponsorship processing times vary. And we're still dealing with COVID-19 pandemic implications with respect to the processing times. I can advise that generally for the past 2 years, the processing of in Canada sponsorship has been taking between 10 and 12 months on average. And the sponsorship of the spouse outside of Canada also varies by the office where the application is filed, and the processing times have been different between the offices, anywhere from 8 to 15 months. That would be the average. So I'll move on to the sponsoring a common law partner category. And I will start with definition here that you'll see on my slides here. So a common law partner is a person that you have lived with for 12 consecutive months in a conjugal, means marriage-like relationship without any long periods apart. And individuals who are filing applications on their own, sponsorship applications, sometimes struggle to define when did their common law relationship start. So as a starting point, you have to look at when these two individuals started residing together. And when we're saying residing, cohabitating together, that doesn't just mean moving in together. It means moving in together and sharing responsibilities as spouses in the same household. And here, when you're talking about that, when we're talking about the 12 months period of cohabitation too, it means not intermittent cohabitation, it's a continuous cohabitation. So for at least 1 year. Of course, there are circumstances where one of the common law partners had to go away for several weeks, and there are legitimate reasons why there may be periods of time within 12 months when the common law partners are not residing together. And that would be employment type of reasons, education, compassionate reasons, such like death of a family member. But the longer individuals stay apart, it may cause issues proving that you've lived together for continuous 12 months. So it is suggested that you wouldn't be apart from each other as common law partners more than a couple of weeks at a time, right? And after this 1 year relationship of cohabitation has been established, and then the application has been submitted, you may still live apart with your common law partner, but again, you have to have legitimate reasons to prove to the RCC why you're residing apart currently, and you have to prove that your common law relationship still stands, meaning you still share responsibilities, and it's spouse-like relationship without legally being married. So every application in this situation will be assessed pertaining to this specific applications, the facts, and with respect to supporting documentation. These applications are more voluminous than the spousal sponsorships, where you're attaching the marriage certificate. So here you have to prove on paper, you have to prove, submit evidentiary proof that you have been cohabitating together for 12 months. So if I'm assisting my clients from the beginning, defining when that common law relationship began, I'm asking them, do you have a joint bank account? If you do, what was the date you opened it? Do you have a joint lease agreement? Or have you purchased real estate property together? Again, when is that date on the documents proving that's when you purchased the property or when you entered the lease? And based on the information that my clients give me in this case, I establish the date where the common law relationship began. Just moving in with someone and not having supporting documents, joint bills, and other documentation will just simply not be valid with respect to common law relationship. You have to have a volume of documentation, and you have to be clear about what documentation you're providing to establish the common law relationship. Here is with respect to eligibility to sponsor, it's the same as I mentioned earlier with respect to the spousal sponsorship, and same goes for the undertaking, financial undertaking. It is 3-year period financial undertaking from the time your common law partner becomes a permanent resident of Canada. And again, there is no minimum financial requirement to sponsor a common law partner. Simply have to prove you're not on social assistance except disability. Someone on disability can still sponsor. I suggest still providing the employment letter from your employer if you're employed. That is in the document checklist. The document checklists published on the RCC websites are very comprehensive. Definitely, if you are completing a sponsorship on your own, carefully read the guides that come with the forms and are accessible on the RCC website, and make sure that you check whether there are country-specific instructions in the document lists with respect to the specific country of origin where your partner is from. There may be additional documents that you have to submit. Generally, the only original that has to be submitted with the sponsorship application is the police certificate, so police record check, or may have to be several record checks if your sponsored common law partner or spouse has been residing outside of Canada in the countries for 6 months or longer since the age of 18. So each of those countries would have to require a separate police record check, and it would have to be an original. And if it's not issued in English or French, it would have to be accompanied by the original of translation as well. But country-specific specifications may include other documentation that has to be submitted in originals. So it's important to check that and make sure that you're submitting a fulsome application. If you are submitting the application that is incomplete, it will return to you. For the sponsorship applications, it's not the case that the ARCC accepting applications and then requesting additional documentation. If you missed anything, they will return the whole application package. And the issue is that sometimes it takes them half a year or longer to return you the package just to say you submitted the application that is incomplete. These are the missing documents, and you now have to refile it, right? So from the outset, it is very important that you are submitting fulsome application, right forms, all the supporting documents that need to be in the package, the originals of police record checks, the correct filing fees, and then reviewing everything, making copy of all the documents provided to RCC and sending them by courier. sending them to the correct address, right? So there are a lot of factors, and that is why in many cases couples hire lawyers to do this work, to prepare and submit application packages, sponsorship application packages, just to make sure that the application is complete, nothing is being missed, and the case is being processed in a timely manner because nothing is missing. So I would take some questions now at this point. If there are questions, put them in the chat. I will say a few words about conjugal partner sponsorship before I take the questions. But if you have the questions at this point, please place them in the chat, and Hisam will let me know what questions are there. So what is conjugal partner sponsorship? So conjugal partner class is only available in certain very limited situations, and a conjugal partner is a person living outside of Canada that you have been in a genuine relationship with for at least 12 months, where marriage or living together has not been possible. And there are reasons beyond your control why you cannot either reside together with this individual or marry them, right? And that generally concerns, the reasons are, as I included in the slides, immigration barriers, religious reasons, sexual orientation reasons. So that is very limited circumstance where you can sponsor a conjugal partner. Although the word conjugal is not defined in legislation, there is a number of factors that would assist to lead to the conclusion that this is a conjugal relationship. So again, it's where marriage is not possible, living together as common law partners is not possible, and this is the only way to sponsor someone. It has to be otherwise the same relationship without marriage or common law, exclusive romantic relationship, where you have a relationship as spouses, right? So, but just cannot be married. And it doesn't apply to individuals who are currently in Canada, because then there are really no reasons why they cannot reside with their partner and get that 12 months in of cohabitation and apply for in Canada common law sponsorship, and there is no reason that they cannot marry each other. Again, the length of undertaking, financial undertaking, is 3 years after your conjugal partner becomes a permanent resident. And as in previous instances, there is no minimum requirement, financial requirement, to sponsor a conjugal partner. I have done several conjugal sponsorships, and it's just, again, it's more complicated than, let's say, spousal sponsorship, in the sense that you have to explain why marriage or common law cohabitation is impossible, but it's truly possible to sponsor a common law partner. It just requires additional evidence on paper. So I'm looking at the chat right now, and I will look at the questions here. I'll read them out. Can a sister sponsor brother or sister? So one of my slides, Hakima, is about sponsoring a sibling in certain situations. So I will address that later, if that's okay. So Riyadh asked a question: when sponsoring a spouse living outside of Canada, can we apply for a work permit together with the application? That's a good question, Riyadh. So the work permit applications are only can only be submitted with a sponsorship for in Canada spousal sponsorship processing class, and same pertaining if you're sponsoring a common law partner or a conjugal partner within Canada. You can apply also for open work permit. However, what I've been noticing for the past 2 years on files, only about less than 5% of my clients who applied within Canada got the work permits. So in my opinion, that is probably, and I can only speculate here, but I think the pandemic has definitely created a huge impact on the RCC processing times and resources. And there are other factors, the Afghan crisis, the Ukrainian crisis, and they are just not processing. They have not even been processing the work permits for in Canada class. I mean, they say that they are, but again, I only got work permits in several cases. In most cases, they just approved the application, the sponsorship application, let's say within 10 months, and never issued a work permit. And obviously, once someone becomes a permanent resident, they don't need a work permit anymore. But you can still apply for an open work permit if you're sponsoring a spouse or common law or conjugal partner from within Canada. You cannot apply for a work permit with a sponsorship application when sponsoring a spouse who resides outside of Canada. Nonetheless, if you submitted the sponsorship, the outside sponsorship, nothing precludes your spouse or common law partner living outside of Canada finding an employer who would assist them to get a work permit. Obviously, it's more complicated that way, but it's possible to submit a separate application for a work permit, but you cannot submit an open work permit application with a sponsorship for a spouse living outside of Canada. So I hope that is a clear answer to that question. There is another question. I'm a Canadian permanent resident and planning to submit a conjugal application for my same-sex partner who is residing outside of Canada. Currently, I'm a student and I have some savings. We can get married in our home country as it's not legally recognized. We applied for her visitor visa last May, but did not hear anything about it, and put in the second application this April, and the first one was withdrawn in May. We don't have any official documents, but photos, translated chat, travel tickets, and my visit as well. We tried to Denmark, but she was refused as they think she's unmarried. It's a little bit unclear. So the visitor visa was refused. Do you think we can go ahead with her conjugal application while waiting to hear back for the second visitor visa application? So it sounds odd, but here the visitor visa refusal is a positive factor for the conjugal sponsorship. In fact, if the second visitor visa application is refused, again, it's a positive factor, because for conjugal partner sponsorship, your partner has to be residing outside of Canada, and there should be some barriers, and that includes immigration barriers as well, besides the not possible same-sex marriage in the home country. So this is a really good case for the conjugal partner sponsorship. So you can go ahead and apply to sponsor your partner, and I even suggest that you should do it before getting a response on the second visitor visa application, because if the visitor visa application is approved and then your partner is able to come here, then you shouldn't be submitting the conjugal application. Then you should be getting married here and submitting a spousal sponsorship application. But right now you're eligible, and it's a perfect scenario for the conjugal partner sponsorship. And if you want to reach out to me to speak about this further, we can do so, right? But that's what the conjugal partner sponsorship is for this type of situations. And the fact that you're a student, again, as I said, that doesn't preclude you. As long as you're not getting social assistance, you're eligible to sponsor. So that's you should go ahead and do so. Another question is, do the spouse rules work for polygamous marriages too? They do not. No. As far as I know, they don't recognize polygamous marriages. Another question is, while the sponsorship application is in the process, can we apply for a visitor visa for a spouse? Also, is there any impact on the sponsorship application if we apply for the visitor visa? Nothing. If you have a spouse living outside of Canada and you applied for sponsorship, nothing precludes you from nothing precludes your spouse from applying for a visitor visa. However, there are countries where they simply seem not to issue visitor visas even to spouses who are married to Canadian citizens or permanent residents, right? So depending on, if I have clients who are outside of Canada, who are being sponsored, and we submitted the sponsorship application, I will advise and I will say my honest opinion about whether I think the visitor visa will be approved or not. Because in some cases, really, even let's say if we take right now, India, it takes over 12 months definitely to process a visitor visa. So it make no sense if you're waiting on this sponsorship processing for 12 to 15 months. It may make no sense to even apply for a visa that will take as long as the sponsorship processing. And some countries, as I mentioned, they simply will not honor the visitor visa application for a spouse. They will reject it. Rejection does not negatively affect the sponsorship application. So you can still try to apply for a visitor visa, but in many cases it will be rejected. It is very different for individuals who are from a visa exempt country. I constantly have individuals from the US or from European countries who are married to, who are even just engaged to Canadian citizens or permanent residents, coming to Canada and openly saying in the border, I'm coming in to get married and I have a dual purpose of attending Canada right now. And there have been no issues at all with this type of openness with the border agents. But that unfortunately doesn't work for individuals who are not visa exempt and have to wait months and months, and sometimes, depending on the situation, over a year or 2 years to reunite with their significant other and with their spouse, right? So, but nothing precludes you from applying for a visitor visa, meanwhile, while waiting for sponsorship. And if it's refused, it's just refused. It's not negatively will impact the sponsorship. So another question, arrived in Canada in June 2019 on a visitor visa, got married in September, submitted an application, sponsorship application in November 2019, received PR in January 2021. And it says she was divorced in October 2021 as a result of various household problems. When will she be qualified to sponsor a new spouse? So essentially, if someone was sponsored to Canada, how long do they have to wait after the breakdown of their current sponsorship and relationship to be able to sponsor a new spouse? It is 5 years. It's 5 years. 5 years period, this individual will have to wait before they can, from the time they became the permanent resident to sponsor a new spouse. That's the rule. There is a question about processing time. Someone saying we're waiting for almost 14 months and don't know how it might take. Again, it really depends. The processing times, again, it depends. I can just give you general processing times, but depends on the application, right? We do process, we do assist with very complicated cases too, and then sometimes there is a factor of where there's a criminal rehabilitation, and those sponsorships might take, or 2 years or over 2 years. But if it's a standard sponsorship application and you've been waiting for about 14 months, again, I don't know if it's filed within Canada or outside of Canada and which office, but it's still within the processing times. I would say, it's when it is between the 16-18 months mark, then when you should be actively following up. And you can follow up if it's filed within Canada. Use the web form, use the call center, and if it's filed outside of Canada, contact directly the embassy. There is no point to call the call center. There is no point to really file do the web forms. Should be just following up directly with the embassy and asking whether there is anything outstanding. And sometimes that helps. The regular follow-ups, they would, the reviewing officer will know that there are follow-ups, and sometimes it would remind them about the file, and they will finalize it. The other day I called to follow up on a postgraduate work permit application that has been in the system being processed for over 5 months, and as soon as I called, within 3 days they issued an approval. So just make sure you follow up, but it's still at 14 months. It might be still within the processing guidelines. Okay, I will read. I think there's a follow-up question with respect to the ban to sponsor when you were sponsored yourself. So it is 5 years from the date of someone becoming a permanent resident, not submission of application, if that makes sense. So sponsoring a parent and grandparent, this type of program is unfortunately very hard to sponsor your parent or grandparent through, because it only opens up once in a while. Last year they opened the program for 3 or 4 weeks, and they only let those who applied the previous years, who submitted intention to sponsor and did not get picked, to resubmit their intention to sponsor forms. So currently the program is closed. They're not accepting any applications for 2022. There has been no announcement yet when the application will be opened, but I anticipate that hopefully that it will be open sometime before the end of this year, on the beginning of next year, and that they will be letting new applicants to submit the interest to sponsor form. So generally, eligible Canadian citizens and permanent residents of Canada can sponsor the parents and grandparents to become permanent residents, but this is a lottery type of program. And I listed the steps here, and again, that may change in the future as they're constantly working on changing this program and making it more accessible. although it's a still a lottery, once in a while type of program. So how it was the past year is that you submit the interest to sponsor form, and you get into the pool of all these individuals who submitted the interest to sponsor a parent or grandparent form. And then it's a random selection of those who they invite to further apply for permanent residence. So then they would draw the applicants, invite them to apply, and then within a number of days, your parent, grandparent would have to submit the full application package. And it is, again, a voluminous application, including all the forms and supporting documents. Definitely one of the key documents would be birth certificates, proving the biological relationship to a parent and grandparent. And then the guides have been changing as well for this program. So it's very important to look at absolutely the most current information here. Once we know this year that the program will be opening up, they will eventually, just when the program opens, publish the guides. You have to make sure to review those guides and to look at all the process then. The application will have to be accompanied again by correct filing fees, biometrics fees. The application will have to be submitted, and further at some point the RCC will request additional documents, medical exams, police certificates, so on and so forth. And I would say the processing is likely more than 24 months from the submission of the application. And that's very unfortunate, because if you have elderly parents, you wish to sponsor, and then you have to wait till the program opens up. And even if you're lucky enough to submit the application, the processing itself may take several years. So the good approach to that is a super visa application. You might heard about super visas for parents, grandparents, where it is a visa that allows, it's used to allow parents, grandparents to stay up to 2 years in Canada at a time for a maximum duration of 10 years. I think now they either already switched it or switching it to be able to stay 5 years at a time. I have to look into it a little further, but we do have clients who first applied for parent and grandparent super visa for their parents or grandparents, and then they are still trying to sponsor them meanwhile. And we also have clients who already applied for sponsorship, parent sponsorship, and now applying for super visas for their parents or grandparents because the sponsorship processing is taking so long. So unfortunately, this is not a straightforward and timely, efficient program. And but we were waiting to hear announcement of when is the next opening. And we're often retained to monitor the opening and submit that first step, the interest to sponsor form, to make sure to maximize chances for individuals to sponsor their parents. And so it may take a few years, even if you submitting the interest to sponsor, it may take a few years to actually get drawn, because as I mentioned, it is a random selection. I'm going to look in the chat right now, so because I would like to answer your particular questions as we go. So there is a question saying, my local MP's office found out that the second, so it's again the situation where we talked about the potential conjugal sponsorship. And so the individual says, my local MP's office in Canada found out that her second visitor visa application got security clearance almost 1.5 months ago. So I'm just reading within the chat. And do you think we should wait until we hear back about the second visitor visa application, or state that we are waiting for 14 months before submitting the sponsorship? Again, as I've mentioned, the conjugal relationship only works if while you're still waiting on the visa, or if the visa application is rejected. If the visa application is approved, your conjugal application will not be valid, because you will not have those bases anymore. You would be able to reunite, see each other, get married in Canada, all of that, if your conjugal partner, that is your currently conjugal partner, is granted visitor visa. They will not be your conjugal partner if they're granted the visa. So as I said, the refusals work in your favor for conjugal application. So you should go ahead and apply as soon as possible while you're waiting. And yes, you do have all the factors and basis to apply for. So good luck to you with that. And I said, if you want to reach out and ask me further questions, or you require any assistance, I'll be happy to assist here. So sponsoring dependent children is my next slide. And children are classified as dependents if they're 22 years, under 22 years old, or they do have, and that they do not have a spouse or common law partner of their own, right? So dependent child must be under 22 at the time you're applying to sponsor them, and the time of your submitting the application. And you cannot sponsor them if, let's say, they're 18 years old and they have a spouse or common law partner of their own, then they're not your dependents anymore. So that's important. And as I stated in the slide, children 22 years or older, they only can qualify the dependents if they are unable to financially support themselves. So if there is a child who is over 22 years old and they have a mental disability or physical condition, and that has been medically established, so there is documentation to prove that, you can then still apply to sponsor them. And our office have been working on this type of applications. Because in this situation, yes, the child is over 22 years old, but they are fully dependent financially on their parent, although they're above the general age of the sponsorship eligibility. So once your application is submitted, the age of the child is logged down into the system. So if the child turns 22 after the sponsorship submission, while the application is being processed, your child will still qualify as a dependent. But here again, you have to be careful. If you're submitting an application on your own, you're putting all the supporting documents and something is missing. If you submit an application and it's returned as incomplete, meanwhile the child turns 22, you will not be eligible to sponsor anymore. So that's very important to make sure you're presenting all the documentation at the outset and nothing is missing in your application. And the sponsorship undertaking, the financial sponsorship undertaking for children is 10 years from the date the child becomes a permanent resident of Canada. And again, if they go on social assistance during that undertaking period, you will be the one having to pay that money back to the government. Even if the breakdown of the relationship and you're not speaking with your child, it's still the financial undertaking. It's there, so nothing can be done after you sponsor a child who's permanent resident, who becomes permanent resident of Canada. I want to highlight here too, because sometimes I get calls from individuals who have biological children born outside of Canada, but they're themselves, and the individuals who call me, they are permanent residents of Canada or citizens of Canada. And here it's you have to think about also the citizenship eligibility, right? So if you are born outside of Canada to a Canadian parent, either who's Canadian citizen or permanent resident, you may be eligible for proof of citizenship, right? So that's a consideration too. So sometimes you have to think about not the sponsorship, but what you have to determine on the facts whether this child is already a citizen of Canada and all they need is citizenship certificate. And the proof of citizenship, unfortunately, the processing times right now, it's about 2 years on average. So it takes a long time, but it's a way less costly application than the sponsorship. The filing fees, I think only $75 for the proof of citizenship versus, over $1,000 for the sponsorship. I don't see any additional questions at this point. So I'll move into an early question, sponsoring a sibling. And I think, Hitham, when you sent me the questions before the session that came in, a few questions, they were also concerning sponsoring a sibling. So you can only sponsor an orphaned sibling. What does it mean? So you can sponsor orphaned brother, sister, nephew, niece, or grandchild if they're related to you by blood or adoption. Both of their parents passed away. So again, if you have a sibling and one of their parents is still alive, you cannot sponsor your sibling. And in addition, the orphaned sibling or nephew or niece or grandchild have to be under 18 years of age, and they have to be single. They cannot be married or in common law or in conjugal relationship. So it's different from, sponsorships in the United States, where you can sponsor a sibling of any age, of any status. You can sponsor a sibling who's married. It takes a long time, but in the US, you can sponsor someone for a green card in that situation. Canada is different. You can only sponsor an orphaned brother or sister, right? So both parents have to be passed away, and the sponsored brother or sister have to be under the age of 18, single, and you have to prove the relationship by blood or adoption. And as I stated here too, the RCC highlights here the factors that are in play where you cannot sponsor your brother, sister, nephew, niece, or grandchild. And again, if they're not orphaned, if one of the parents is alive. In the situation, they specifically highlight in the situation where you don't know where the parents are, you don't know whether they're alive or where they are, you cannot sponsor your sibling then. Even if they've been abandoned by their parents, you still cannot sponsor them. If someone else is taking care of them, like a legal guardian, while one of both parents are still alive, again, it prevents from sponsorship. And they also included here, if the parent is in jail or otherwise detained, you cannot sponsor a sibling or nephew, niece, or grandchild. So unfortunately, that's a very limited situation where you can sponsor a brother or sister. I get many calls about from Canadian citizens and permanent residents about sponsoring their siblings. Here you have to look into kind of a temporary pathways for them to come to Canada. So one that comes to mind, the most obvious, is to study, right? So your sibling can apply to get enrolled into college or university. Applying for study permits has been getting harder. We get a lot of volume from many countries with respect to international students attending universities and colleges, and there have been many refusals over the past 2 years of study permits, but it's still a good way to attempt to come to Canada for someone who is young and wants to further their education. And as you may know, if someone receives a study permit, then they can work up to 20 hours during their academic sessions for any legal employer, and up to 40 hours during the scheduled academic breaks. And then if they're attending a study program that is 2 years in length or above 2 years, they will be issued a 3-year postgraduate work permit. And then hopefully they'll be able to gain work experience to get residency. But unfortunately, there is no straightforward way to sponsor a sibling. If there are strong humanitarian compassionate considerations, those should be explored definitely, but humanitarian compassionate grounds have to be very valid, and it's definitely a small percent of HNC applications that get approved. So you have to consult a professional here and see what is possible, but likely the study permit route will be the way to go. Or if your sibling is, they don't want to study, but they have work experience, they have skilled work experience, and they may have skilled experience in the occupation that is in demand in Canada. Maybe they can find an employer who can assist them of eventually getting a work permit. So you have to think about temporary resident first over the sponsorship, simply because the sponsorship is only available if your sibling is orphaned. So I'm just checking the chat here again. There is a question about the Lonely Canadian program, and that is actually pertaining my next slide. That's what I was going to speak on. So the Lonely Canadian program, essentially here we're talking about sponsoring other relatives to become permanent residents of Canada. And it's very limited circumstances, again, that you can sponsor your relative under this program. So you may sponsor one relative only related to you by blood or adoption of any age, if you meet the criteria that I listed here. And this is from the IRCC website, word by word. So first, you have to be the sponsor has to be a Canadian citizen or permanent resident or registered Indian under the Indian Act, and you must have no relatives in Canada who are a Canadian citizen or permanent resident, or someone who registered Indian under the Indian Act. So the starting point is that you have to be essentially in Canada, having no relatives in Canada who are Canadian citizens or permanent residents, right? So you at the starting point, you don't have a spouse, you don't have a child, and you don't have extended family members, parents or grandparents in Canada or in any other country too who are Canadian citizens or permanent residents. You are first, it sounds like you have to be the only living Canadian in your family, right? And then in addition to that, the individual who is sponsoring, it can be just one relative, and so that's where, well, that's why it's called Lonely Canadian Program, right? It's, you only have that one relative, period, right? That who you can sponsor. And that's considering relatives in Canada and outside of Canada. So you must not have any relatives in Canada who are Canadian citizens, permanent residents. And additions, you only have this one person to sponsor. If, let's say, you have only one living parent and no one else in your family at all, you can sponsor your parent under this program, under the Lonely Canadian Program. But if you have two parents, right, and no other relatives you can sponsor, and you have no relatives who are already permanent residents and Canadian citizens, you cannot sponsor that one parent. It has to be only one person in your family that you have as a living relative. That's what essentially the program is for. So, but that individual, that relative of yours, can have a family of their own, like a spouse and dependent children, and then you can sponsor them. But it's such a really limited program, right? It's in instances where, I don't know, it's such a rare program. It's good to know that this program exists, but to be honest, I have not got to do a sponsorship application under this program, simply because generally there are individuals who have relatives to sponsor outside of Canada other than this one person, and then they become not eligible for this particular program then. And we are getting close to the time that really that's what I wanted to speak to you about today. I will leave you'll see on the slide, there's my email address, my phone number. So one question, the sponsoring person could be married. Do you mean here that the sponsoring person are we talking about the Lonely Canadian Program? Okay, the person in Canada. Well, let's think about that, whether they can be married in the sense of, again, if they already married to someone who's Canadian citizen or permanent resident, no, they cannot sponsor under Lonely Canadian anymore, because then they have they already have a relative who is Canadian citizen or permanent resident. I suggest, Carlos, that you email me and just explain a particular situation, and we can address that. And I see another question here with respect to the office charges as fees. Question from Shawab. We quote legal fees, again, depending on the case, right? So contact me, explain the situation. With respect to the family sponsorships, I generally provide a first free consultation on the phone that we can discuss it. And then once I fully know your circumstances, then I would quote the fees and provide the information on precise filing fees as well. So you have my email address now, and this is my direct phone number on the screen. It was a great opportunity to provide some information to you. I again thank HITAM and Rights and Responsibilities Awareness Initiatives. I'm so glad that this organization exists in London, and at Siskinds, we're certainly willing to provide free information sessions and community support. Thank you very much to everyone who attended.
Thank you very much, Elena, for this wonderful, fruitful, and useful information. That was really delighted. I would be very grateful if our participants could fill out the feedback form. This will help us to improve our services. That was delighted. Thank you, everyone, and have yourself a wonderful day. And looking forward to see you in another sessions with Rights and Responsibilities Awareness Initiative. Be well, everyone.
Thank you, Hitham. Thanks, everyone. Bye-bye.